So welcome everybody to today's presentation. Just a couple of housekeeping items just as we begin. If you could just keep yourselves on mute while the presentation is going on, and then feel free, you can unmute yourselves to ask any questions that you might have, or if you feel more comfortable and you want to use the text chat, you can do that as well. And I could monitor that and bring the questions forward when it is time. So again, thank you today for joining us. We appreciate you being here, and I would like to introduce our guest speaker, Deborah Meltzer. She is from the Ottawa area, and she's an intellectual property lawyer.
Thanks.
So welcome, Deborah.
Thanks. So yeah, I'm an IP lawyer specializing in trademarks, copyright, patent, more on the litigation side. I do a lot of online branding enforcement. And yeah, we're locally based in Ottawa, but we service clients across Canada, and it's a convenient hub just because the intellectual property office is just across the river on the Gatineau side. So I'll just start by sharing my screen. Are you guys seeing the full screen mode or this screen?
I see the one with slides on the side.
Why is it?
Is it that last one? Yeah, that one there. If you.
I know, and it's popping up on a different screen.
Oh, okay.
Okay. Sorry about that. Can you just?
No problem.
This is the problem with multiple screens, guys.
I think if you start the presentation and then you see which screen it's popping up on and then click share screen, you might be able to select the one that it's full screen on, maybe.
Okay, I just won't be looking in the camera, guys, if that's okay. So let's try. That would be just a second. This is terrible. This presentation is about like online tech,
No
and I'm
worries.
struggling with my screen. Okay, hold on. Now you guys see the full screen?
Yeah, we can.
Okay, so that's fine. We'll do it this way. And then if I just see. Okay, that works. Okay, hi everyone. So for those of you who participated in the talk we had in September, this is sort of going to be a follow-up to that one. So originally we discussed intellectual property in general, trademarks, patents, copyright. Today, we're going to focus on intellectual property in the online world. And just obviously as the marketplace is shifting or has shifted dramatically in the past 15 years, and especially with social media platforms, virtual realities popping up, these are questions that I'm getting asked quite frequently now. And businesses should be really considering the implications of marketing, branding, and really creating a presence in the online space and what that means from an IP perspective. So I'll go through these concepts. I'm going to try not to get into too much detail, but essentially my goal today is going to be to at least bring to light some of the topics and concepts you guys should be thinking about when marketing your business in the online world. So I'll touch on domain names, website considerations, social media, strategic use. And then I'll briefly get into virtual realities and what that looks like from a branding perspective, and what the heavy hitters are starting to do. So domain names, as I'm sure most of you who have businesses know, it's a very important business tool. There's a lot of value in a domain name. That's how you drive your traffic. It's how you build your presence. It's where, you know, your online information is stored. It's where clients will go to seek the information they need. It may also be, you know, linked to your website where you sell your products or offer your services. And we have to consider the value in the domains, what rights we have in a domain name. And then if we have issues with the domain name, if someone else, let's say, is using a domain name that you want, what recourse do you have against that person? And on the flip side, if someone is trying to take your domain away from you, what rights do you have in that domain? So just at the outset, when we say domain, you know, we hear terms like URL. So the original part of your URL is going to be your second level domain. So typically, if you have a trademark, it would be www. whatever that is, .com. .com is one of the most coveted top level domains. But as we know, we have, you know, country codes, we have .cas, .orgs. And then the value of a particular domain, .coms, like I said, if you can secure that .com juxtaposed to your business name, I would say secure it at the outset. But on the other side, if you're a Canadian company, there's tons of market research suggesting that Canadians trust .cas. So strategically, if these domains are available in association with your brand name, I would say scoop them up as quickly as you can, depending on the price, of course, and availability. But essentially, this domain is, as we know, it's a unique identifier that points to an internet website, and as I said, is an incredibly valuable business tool, given the nature of marketplaces today. A concept that often gets confused is, okay, I have, you know, trademark rights, I have a trademark, but, you know, I should be entitled to a domain of that trademark, and sort of like, where do we draw the line? Or if you file for a domain and you're the owner of that domain, what does that mean relative to your trademark rights or the trademark rights of a third party, for example? So for a trademark, you can have several different owners of the same word in a trademark. It could be different jurisdictions if it's not confusing, and it could be based on different goods and services. So your trademark rights don't inherently give you exclusivity to a word. It's only how that word in association with the goods and services that you're using it with, and the goods and services that you've developed reputation in association with. So for example, I think I've given this example before, XL Gum and XL the software, it's virtually the identical trademark, but the reason they're able to coexist is because one is gum and one is software, so consumers are very unlikely to be confused. Domain names are different in that there is only one global owner. Once you secure that domain, that specific domain, no one else can have it because it links to a particular website, that you have ownership in that domain. And unfortunately, regardless of whether or not you have pre-existing trademark rights, anyone can register a domain name. So that's why you have to be very conscious, especially in doing your due diligence. It may be an incredibly important branding consideration if you're trying to figure out whether or not you should name your company, let's say Sunshine. Is the domain, you know, sunshine.ca, is that available? Is that going to be critical to your business? If you don't have that, our customers going to get confused. I would definitely check availability of these domains, buy them up, secure them. You can redirect if you can get sunshine.ca, sunshine.com, all redirecting to your website. It's incredibly important. And these rights are mutually exclusive. So domain names, you have like a property right. Trademark rights is based on use, and one doesn't entitle you to the other. So we have to keep those concepts distinct. Common disputes or issues with respect to domain names. So we see a lot of cyber squatting, and this is usually in the context of very popular or famous brands. So we may, or very generic domain names, like for example, shoes.com, something like that. Certain companies or people may have this, illicit intention to cyber squat. They may try to rack up as many of these domains as possible with the intention of selling them at a premium rate. And you may be in a position where, you have to pay the price if you want to secure the domain. And there's very little recourse when it comes to getting a domain at the start of your business if it's already been purchased by someone else. Typo squatting is another one we see often. Deliberate misspellings in domains to redirect traffic from the intended website to the website of the squatter. And then counterfeit goods is the one that I deal with most commonly. Again, this is usually in the context of more famous brands, but it's something to keep in mind. Someone may be using a domain that is not identical to your domain, but is close enough to confuse people as into the belief that whatever products you're selling are the real thing. So for example, if you have, I don't know if Nike has Nike.com, I'm assuming they do, but if you had one that I dealt with a similar famous brand was something like, I'm going to use Nike as the example. If you had Nike Canada Outlet.com, and that wasn't a legitimate Nike website, the average user would assume that perhaps that is a legitimate website. And if they're selling counterfeit Nike shoes, you may be duped into the belief that that's in fact Nike selling it. So those are the sort of concerns we would see in the context of these more prevalent brands. And so what do you do about that? If you see someone is using or trying to trade off your trademark in the context of a domain with a fake website, and it's just, driving business away, your customers are getting frustrated, what do you do? So if it's a .com, and certain top level domains, the registrars that you register these domains with, usually in their terms and conditions, they have mandatory dispute resolution policies that force you to arbitrate these disputes at the World Intellectual Property Office. So this kind of thing is called the UDRP. It's almost like it is litigation. You're not really in court. You're before a panel of decision makers, and everything is done in writing. So there's no hearing. Essentially, you file a complaint, it goes through the bureaucratic system, and then they spit out a decision. You have the opportunity to file evidence. Usually, if in cases where there's straightforward bad faith, and it's like, hey, I'm Nike, these people are clearly not Nike, I own the trademarks, it's straightforward. In Canada for .cas, we have a similar procedure, but it's governed under CIRA, so it's a CDRP. These types of disputes, they're not as expensive as litigation, and it achieves a very similar result. So you could ask that the registrar transfer the domain to you or remove the ownership of the illicit user. So this is sort of like procedure not very many people know about, but if it's really hindering your business and you satisfy the criteria, it's absolutely the way to go. You don't want to be tied up in the court process. And also through the UDRP system, what's interesting is it's actually incredibly annoying when you're trying to do some due diligence to see who owns these illicit websites or domains. They're able to use privacy proxies. You can't actually see their location, their name, what's going on. When these disputes are initiated, the registrars are mandated to reveal this information, so you gain insight. I mean, we had a crazy dispute where it was borderline extortion, and the website an issue was threatening to release confidential information if certain monies weren't paid, and we had no idea who this person was, if it was like a disgruntled former employee, etc. So just by virtue of initiating the process, we were able to bypass the privacy proxy and see what was going on, where they are located, etc. So even just with that information, it's incredibly useful in terms of deciding what the next step should be. And not to go into too much detail, but if We would only recommend going down the sort of domain takedown path if you could satisfy the 3 criteria, which is it identical or confusingly similar with the trademark, that the actual user of this illicit domain, that they have no legitimate interest, and counterfeit, the sale of counterfeit goods does not count because it's illegitimate. But the most important and difficult one to satisfy is whether or not the domain name has been registered and is being used in bad faith. And that's where a lot of people get stuck, because you may have someone who's not necessarily a competitor or is not really using the domain in association with the website, but you want this domain. If they're not using it in a way that's ripping your trademark off, it's going to be incredibly difficult for you to be successful in this path. So again, it's very fact specific, but important to know down the line if you encounter this sort of dispute. So again, just to conclude on domain names, they're incredibly valuable assets. I would say scoop them up as quickly as you can. When you're considering your branding initiatives, check availability, do your due diligence, see what you can buy, see what the availability is, and consider whether or not you should, register if you have a product, for example, that is susceptible to counterfeit goods. Scoop up as many variations of your domain as you can so they redirect to your website. Again, cost permitting. So let's get into websites. So certain things we need to think about when we have a website. There are trademark considerations, copyright considerations, terms and conditions, privacy policies, third-party content, and anti-spam legislations, all things that need to be considered when operating a website. In terms of issues, when I'm dealing with clients in the context of their websites, copyright is usually the one that comes up the most. At the outset, when you have a website design, typically businesses will outsource this unless they happen to be developers themselves. If you're outsourcing your website design, you need to ensure that you have all your ducks in a row and that what's actually being created belongs to you. At the outset, when you have copyright, if you have an employee, for example, an employee of your business that's creating your website content, the presumption in Canada, at least, is that anything that employee creates that's in the scope of their job directly benefits the company, belongs to the company. However, if we're outsourcing and we have third-party contractors that are creating these things for us, the presumption is that the ownership of the content in terms of copyright belongs to the contractors unless there is a written agreement to the contrary. So don't overlook these things. Contractors, I've seen this quite often, they'll have these boilerplate agreements that they have you sign. This is, our work service agreement, please sign it and we'll get the website up and running for you. But don't be afraid to look at those agreements. You don't have to sign it as is. They can always be revised. If you're unsure about certain provisions, speak to a lawyer about it, especially if your website or your content is going to be incredibly important to your business, which typically it is. Photographs used on website is an interesting one because a lot of times what do? We start Googling photos, we're copying and pasting. Can you do that? Can you not do that? The answer is always, it depends. If you're using, if you have, for example, a Shutterstock account and you want to use these, public domain images, please read the terms and conditions. I've been involved in at least 3 huge litigation disputes over, a famous artist's graffiti in New York City. Someone takes a photo of it, someone uploads it to one of these shady websites. A web developer thinks that they have the ability to use this image. They'll take the image, they'll sell the thing to the client. All of a sudden, the client gets sued. So a couple of things to keep in mind: where third-party images are being taken from, what are the rights in those third-party images. You want to look for things in the terms and conditions. Can I use this for commercial purposes? There's something in Canada called fair use, there's fair dealing in terms of copyright. Usually that applies if it's for personal use, non-commercial purposes, educational purposes. So for example, all the images you'll see here, this is for educational purposes. So if I copied and pasted them from a website, I would be exempt from copyright infringement. Typically not the case when we have a business offering their goods and services for commercial purposes on a website. It's a little bit different when, you know, whether or not you're selling merchandise that, you know, prints these images on the merchandise, or whether or not you're just using it for advertisement. You have to be incredibly careful. And then I would say, again, going back to the contracts or agreements between these web developers and your business, look to see what the indemnity provisions are. What happens? What warranties are they giving you? And if you, to the best of their knowledge, that doesn't infringe any third-party content, but in the event you get sued because of something they did, are they indemnifying you for those costs? These are all provisions that always get overlooked, and they need to be looked at. So read your agreements. The agreements need to make sense to you. If they don't make sense, you know, talk to an IP professional and just make sure that you understand exactly what you're getting yourself into. So copyright protection on websites. This is also a question I get asked quite often. How do you, once you have your website, you have your content, everything is kosher, you ensure chain of title, everything belongs to you, there's no third-party content. How do you prevent others from actually taking your content that you've created? So there are obvious copy controls, read-only works, watermarks, access controls is a big one now. And in the recent years, copyright law in Canada has extended to include something that's called a technological protection measure. So that could be, it's defined as a lock and key with a very broad interpretation. The only like jurisprudence in Canada that speaks to technological protection measures thus far is Nintendo. So in Nintendo, their technological protection measures was, you know, their video game, the actual cartridge fitting into the slot of the device of the gaming system, but also the software code that enabled access to the game within the thing itself. And there's going to be new case law developing in Canada. I'm actually involved in a huge lawsuit now that is, we're seeking to assert that passwords and login information are also technological protection measures. That's how you control your copyright work online. And why is that important? Because the law shifted to include provisions that even if someone doesn't, let's say, steal your work, but if they're messing with your password and login system, it's deemed to be the equivalent as if they stole your work. So there are important things to set in place that you could really, you know, scare people and safeguard your work as much as possible. Trademark consideration. So these ones are a little bit more obvious. Again, domain names, it's important. The use of a domain name can be use of a trademark, but it's not, it's more likely considered trade indicia, but it's nice if it's aligned with your trademark. Do your due diligence. I always say to brand owners, get on Google at least once a month, type in your trademark, see what's going on out there. On your website, you likely are including your logos. Again, we want to think about registrability. If you're trying to launch a new brand, are those trademarks available? Can you use this trademark? Are you free to use this trademark? And then another thing that I see clients get wrong all the time is, you know, the display of the relevant symbols. So anytime you're using a logo, a trademark, even in the text, if you have a tagline, you can always use the little TM next to your trademark. It doesn't matter if you have a registration. The little R in the circle, that is only for registered trademarks. So still, if you don't have the resources yet to file for your trademark, but you still want to create brand awareness and, you know, tell the public that, hey, I'm using this as a trademark, especially in the context of, you know, taglines or things that could, you know, we don't know if that's a trademark or not, throw the TM wherever you can. We always recommend that. a good habit to get into is to maintain records of your trademark use through your website. And what do I mean for that? We hope for the best, we plan for the worst. And as someone who's in litigation and then, you know, something comes up, all of a sudden we have to prove use. When did you first use your trademark? How did you use your trademark? What did you use your trademark in association with? There are internet archivers who don't unfortunately save every single day that your website's been active. So it's just, if you have a marketing department or if you're a smaller business, I would say a good habit to get into is to take screenshots of how your trademarks are being used on your website, dated, and, you know, keep them in a nice organized folder. Just in case something were to come up, you will be like your IP lawyer's best friend when they ask you for this information. And I have this awesome, you know, archived folder with all this information. Here you go. Again, hope for the best, plan for the worst. Keep track of your trademark use. And then non-traditional trademarks, something to consider as well. The law in Canada changed in 2019. I discussed this in our first talk. So beyond logos and word trademarks, we now have sound trademarks and holograms as trademarks, moving images as trademarks. So think about your branding at the outset, and on your website, if you have a little jingle when people click something, or if you have a little, let's say a little running man across the street, all of those features of your website, if you use them as a trademark, are protectable as trademarks. Get really creative when you think about your branding and your online presentation. Think about what can and will be used as a trademark. Use the TMs. And again, when we're talking about maintaining records in the context of non-traditional trademarks, if you want to file for registration because you have this great sound or this great moving image or a great hologram, you have to be able to prove what's called reputation and distinctiveness in order to be able to register these trademarks. So that's where good record keeping comes in. It's proof you may have to show, not necessarily in the context of a litigation, but if you want to register your trademark. Patents is something that's interesting, especially in the context of websites or software in general. Software in general is not patentable subject matter, but practical applications of software can constitute patentable subject matter. The most famous one that we always refer to is Amazon's one-click. So if you're launching a particular, and again, I won't go into too much detail here from the technical perspective, but if you're launching a website that does something fairly unique in a unique way that you're unaware of in the marketplace, before you launch, I would say it's worth it to have, you know, a conversation with a patent agent, an IP lawyer, just to see if there's something patentable there. It may be worth filing a provisional application and trying to see how I'm doing this different thing. And even if other competitors are doing something similar, it doesn't mean that you don't have patentable subject matter within a specific component in the chain of things that your website may do. So again, if you're not sure and if you're offering something unique more than just like a Web 2 or a Web 1 website that, you know, just provides content for people to browse, if there's an interesting process in the thing that you're offering, speak to someone about it to see if maybe there's IP there. Terms and conditions. This is something that a website has to have. And you want to ensure that your IP provisions are incredibly clear, are incredibly tight, with respect to non-permitted uses, or if you're offering a website that has, you know, certain memberships or account details, what you can and can't do with the content. You want to be able to stop someone or sue them for breach of contract should they violate this. So we were talking about the sort of safeguards, the copy controls, the technological protection measures you can insert, but obviously there are ways around that. Your website terms and conditions, they outline the way that your website can be used, but it's creating a binding contract between the user and your company. And then it gives you recourse to say all your technological protection measures failed, the copy controls, they got around it, whatever they did, in addition to your copyright action against them, you have an action for breach of contract, which is easier to sue for, very clear if it's in black and white. It's worth it to invest in a lawyer, I would say, to review your terms and conditions, make sure that you're not missing anything, and tailor it to the particular business offering and setup that you have. And click acceptance is incredibly important. The law in Canada is very divided, whether or not just the mere action of browsing a website, is that good enough of acceptance of terms and conditions if they're all the way at the bottom of the page. Some decisions say yes, some say no. The safest thing to do is to have a click accept, that they can only access your content or purchase the thing or do whatever they're doing on your website as long as they agree explicitly to the terms and conditions. And then it's sort of like they can't say that they were unaware of these terms. So just to go through website summary, you have copyright considerations, consider ownership of all aspects of your website content, how you can employ technological protection measures, trademark considerations, think about your domain names, due diligence, registration, how do you brand your website, non-traditional trademarks, patent considerations, whether or not you have a unique process on your website, contract work, so again, liability to third parties, assignments, agreements, all comes down to chain of title. Make sure you own all of your content going forward, especially if you have ongoing collaborations with content creators. Make sure that those agreements are really, really solid. Terms and conditions, incredibly important to have good ones, and make sure that your users are explicitly accepting your terms and conditions. I didn't go into privacy policies or anti-spam, but again, important to make sure that you're in compliance with these regulatory regimes. Privacy policies, essentially, most important takeaway, if you have a website where you would routinely be collecting personal information from your users, you need to have a very good privacy policy in place. There's legislation in Canada that is specific to this type of identifiable data, so ensure that you're checking all the boxes there. And then anti-spam legislation as well. If you have newsletters that go out, certain things like your unsubscribe link or button needs to be visible. There are all these regulatory issues that you need to be aware of. So I'll get into social media a little bit. That's the hot topic of the day. One thing, besides the conventional uses of social media to advertise and brand, something that I think a lot of companies take for granted or don't appreciate is that if let's say you have a website or you're advertising on business cards, etc., and you're trying to let people know that, hey, I'm on Facebook, I'm on Twitter, find me on Twitch, etc., your use of these icons has to be in compliance with the guidelines set forward by these companies. So you're not allowed to just change the colors, invert the colors, change the size, do whatever you want. And we see companies get this wrong all the time. Take the time, if you're going to include these icons, take the time to go on Facebook's website, on Instagram's website, to see how you can use these third-party icons. Obviously, they want you to advertise, they want you to drive traffic to their platforms, but you need to ensure that, hey, how can I use the Facebook icon in my advertisement? There are rules that you need to follow in terms of branding. Handles, social media handles. This is very similar to domains. You may, if you have a business that's the branding or the marketing is going to be very Instagram heavy, you're going to want to ensure that those handles are available. It's incredibly frustrating and difficult to sort of retrieve these handles if they're already been secured by someone else. So again, branding considerations, you should be doing your due diligence for your trademark choice. Consider whether or not the social media platforms that you want to use throughout branding and advertising your business, are those handles and names available to you? And the same thing with website considerations. There's sort of like a package deal. What is your presence online? the best thing you could possibly do is to ensure brand consistency. That's the ideal scenario, not always possible. Very annoying if you have to add like an underscore and then something else to make it jive, or to substitute from like the true good handle that's already been secured by someone else. You don't want to have confusion. You don't want to lose your client base because they're confused with a pre-existing handle. And I would say, again, secure as many as possible. Enforcement. This is a little tricky. So I'll first start off by saying, be careful what you share online, just because all of these websites, when you upload content, there are, again, terms of use, licensing that you're inadvertently agreeing to in their terms of use. But say someone shares something on Instagram, it doesn't mean that you're able to reshare it. You may be violating their copyright by doing that. So the safest thing to do is to always seek consent. If you are reposting or resharing something that you yourself did not create, you are unsure of the rights available to it, send a quick DM to the person who originally shared it. Ask for their permission to do it. You don't want to get slapped with a nasty letter. And then on the flip side, in terms of social media enforcement, what do you do if someone is using a handle that is your trademark and you want to get it back? Or if they're trying to sell, again, knockoff goods, or they're trying to compete with you, if they're the second comer, what can you do? Social media enforcement is usually a ticket-based system. Instagram, Facebook, even places like Amazon, which is not social media, but an online marketplace. They try to make it incredibly robot-centric. I would say it's very hard to get a hold of an actual human. However, this system is pretty fast and it makes it very user-friendly. It's a form, it's a short form. They just ask you for your information. You don't always need a registered trademark, but they'll usually ask you for a link to your website. Show, again, website super important with your branding. This is how I use it. This is how long I've been using it. These are the rights that I'm asserting. And then you add a link to the infringing page that you're trying to take down. And again, with Instagram, it's a little bit difficult because if it's an infringer that you're just trying to stop, it's fine. If it's a handle you're trying to get, Instagram is a bit weird about it. By doing this, you may inadvertently compel them to put it into this like graveyard of handles that no one can get. Once it's dead, it's dead. So you have to be clever in what you're asking for. I know that I think there's a checkbox that says, if possible, I may want to take ownership over this handle. So it's a ticket-based system, quick to fill out. You don't need a lawyer to do it. You could do it yourself. But that only really works in two circumstances. If you could prove that someone is impersonating you, or if there's intellectual property infringement. So what does that look like? If you are the first user, it's your trademark and someone is trying to trade off of your goodwill, it won't work if you've not yet used a trademark and someone happens to have a handle that you want. And I've tried, Instagram will not, they absolutely will not just hand over a handle without any evidence of wrongdoing. So a way around this, and it's the top recommended thing to do, is try to reach out to the person who owns the handle to see if they would transfer it to you. It gets a bit tricky for two reasons. Number one, it's against Instagram's terms of use to actually exchange handles for money. If you try to take it online, I don't know. I mean, power to you if you're able to negotiate something. And the second thing is, if you encounter a dormant page or handle and the person isn't in fact checking their direct messages, it becomes tricky to actually contact them. So I would say exhaust all forms, tickets, resources. But again, it's an incredible headache if this isn't something you looked into before choosing your trademark, your brand name, your domain. Check social media platforms, secure what you can secure at the outset. So what time? Okay, so I have about 20 minutes. The hot topic of the day are virtual realities and the metaverse. And I thought it would be interesting to talk about what the heavy hitters are doing in augmented realities and virtual realities. What does branding look like in the virtual world, and what could it turn into? What does it mean for your business? So just for some nice statistics here, in the US and actually globally, we're seeing this increase in trademark applications that are being filed in association with virtual goods and services and NFTs. So there's this rise, and I think worldwide, I checked a couple of days ago, there are, I think, over 2,000 registered trademarks for various virtual goods and services. So it's an interesting thing to think about, because when you file for your trademark, especially in Canada, I would say have forward thinking. So if you're not offering virtual goods today, you can throw in the kitchen sink if you think you may be offering virtual goods 5 years down the line. In Canada, your trademark registration, after you get it registered, you have a period of 3 years where you have to use your trademark, after which it's subject to cancellation based on non-use. But it takes 2 years to get a registration plus 3 years. Throw in the kitchen sink. Worst case scenario, if ever you get challenged, which is unlikely, then those goods and services will be struck from the registration. It doesn't affect the rest of your rights. So if you're offering something, real world goods, but you think you could be transitioning into virtual goods and services, I would say throw it into your trademark applications. And this is just illustrative of certain trademarks and that are being filed. An interesting approach. So Neiman Marcus, for example, and this is all US applications, they're filing for retail store services featuring virtual goods. Ralph Lauren, I thought that this was a really interesting thing to apply for them, because they're typically, so they applied for providing virtual hotel rooms, operating virtual restaurant featuring actual and virtual goods. Ralph Lauren, we typically think of in terms of clothing, consumer goods like that. Virtual worlds don't have the same real world limitations in terms of expansion. So say it would cost you, $1 billion to start a hotel chain. You don't have that same sort of, financial and infrastructure limitations in the virtual setting. So if you want to expand your brand in a way that you can't otherwise expand in the real world, it's a good example of what Ralph Lauren is doing. Forward thinking, what can I do in these virtual worlds? The sky is literally the limits. We see luxury brands like Louis Vuitton. I'll get into what Gucci is doing and other clothing companies, but they're applying for things like providing non-downloadable computer software featuring virtual goods, storage for virtual goods. McDonald's, not surprisingly, they need to get in on this as well. Online retail services featuring virtual goods, whatever that means. Kraft went on a blitz. They filed for trademarks, virtual trademarks for all of their famous brands, Kool-Aid, Heinz, Jell-O, again, operating virtual restaurants, featuring actual and virtual goods. How unrealistic it would be for Kraft to open up a Kool-Aid restaurant and a Heinz restaurant and a Jell-O restaurant in the real world. But in the virtual world, again, it's limitless. You can do whatever you want, whatever works with your branding. And very quickly, this is a trademark application that we filed for real estate services. It's for the Meta agent. So we had to get really creative in how we were going to describe the services. So essentially, because virtual land is a thing now, so we had to craft the services description to make sure that we were including so the retail services in the real world in association with virtual land. Conversely, the retail real estate services provided virtually in association with real land, and then everything done virtually, and then everything done in the real world. So again, you can get very creative with your business models and get very ambitious, because again, you have quite a few years before your trademarks would be subject to cancellation down the line, if and when. So get creative, think about what you can do with this in the next couple of years and go for it. And I think Nike is an excellent example of branding. And really grabbing the bull by the horns in terms of layering up your intellectual property strategy. So let's just talk about Nike's virtual shoes. So they've filed for patents that secure the technology behind their virtual shoes. They file for trademarks in association with their virtual shoes. They've set up Nike Land on Roblox. They are using NFTs to bring the collectible sneaker market into a virtual setting by creating scarcity and rarity in unique designs that are backed on the blockchain through an NFT, and they're selling this for quite a bit of money. They have copyright in the design of the shoe, and if anyone is looking for a side hustle, they are hiring virtual footwear designers, if that's your thing. So this is today what these brands are doing. So it's important to think about, how can I stay relevant? How can I, get in on this? And, the target now is really Gen Z. They're the ones on Roblox. They're the ones interacting and purchasing these virtual goods. So this is just a really exciting example of where branding is headed in the virtual world and online. Gucci is another one that also set up the Gucci Garden on Roblox. So again, yes, they have their trademarks, they have their virtual goods. This virtual handbag, for example, as a fun fact, sold for over $4,000 US, which costs more than the actual bag itself for someone's avatar essentially to walk around with that luxury designer good. But what's the Gucci Garden? How is Gucci trying to reinvent itself in the online world? The Gucci Garden replicates their museum/shop. I believe it's in Florence, and it pays homage to, I think, 15 of Gucci's most iconic campaigns. And what they've done is they've created a new user experience. Your avatar as you enter the Gucci Garden is a completely white mannequin, and as you interact with the different elements in the garden, your mannequin gets colored with the patterns and styles in the unique way that you interact with the Gucci Garden. And then they have, I think there's an actual virtual garden there where a flower gets planted for each new avatar visit. It's a completely different branding take. And again, you couldn't do that realistically in the real world. So they're trying to be really creative with how can we take advantage and manipulate consumer experience using virtual parameters and settings. And Heineken, this is my favorite virtual reality story from a branding perspective, because when people started to hear about Heineken advertising virtual beer, which sounds so ridiculous, they owned it, and their campaign, first of all, this whole thing, I should start by saying, was in advance of the launch of the real world launch of their Heineken silver beer, which is not as bitter, more refreshing. Again, target market was Gen Z, who goes on these virtual settings, virtual platforms, Gen Z. So how are we going to have this crazy marketing campaign? So it was a very ironic and self-aware campaign. Their advertisements included no calories, no hidden ingredients, no beer. And you could go and people were making fun of it, but people were talking about it. And they got over 2 billion impressions on social media because they were deliberately making fun of themselves, but everyone was talking about Heineken silver beer. And then they took it a step further. And what they did is they created real world settings, design them to look like virtual settings with pixelated props, fake beer in the real world. People got to wear fake virtual reality goggles. And again, they set it up at these specific locations and they got people talking. So it's sort of like, no, they are not actually going to sell virtual beer, but the idea of it, to be able to target this market for their real life beer product, it's just an incredibly intelligent and brilliant, innovative marketing strategy. And kudos to their marketing department, who this was a huge risk for them to take, but they were very true to their brand, their playful nature of their brand. And again, this is all about staying relevant. and really, really connecting with the consumer. In the context of these virtual realities, though, I'll just touch quickly on this. From a trademark perspective, from a branding perspective, there are many issues with these decentralized systems, everything being based on blockchains, no one governing authority, no jurisdiction. So it begs the question, if someone has trademark rights in Canada, for example, and someone is trying to rip them off in a virtual world, where do you have recourse? Where can you sue someone? What do you do with when you have a jurisdiction specific trademark, but you're in a non-jurisdictional setting? We don't know yet. It's going to be interesting to see how these things play out. Terms and conditions of platforms, not really in existence right now. Is it going to be based on where the rights holder is? Again, we're going to encounter privacy issues. Do we even know who these avatars are? Should there be a similar system to the domain dispute resolution process where it's arbitrated at the worldwide level, or should it be like social media reporting where it's a ticket-based system? We don't know yet. It remains to be seen. There aren't any documented disputes for infringement yet, so it's going to be interesting to see how it plays out. What's going to end up happening if it has to be centralized like that? We're gonna essentially be centralizing a decentralized system. So we don't know. Brands are jumping into this full force. It's obviously a lot easier if you have the advantage of being a very famous brand like these luxury goods, but we'll wait and see. But again, not to be discouraged. You have to continue to stay relevant. Think about whether or not there's some potential to gain some, untapped market share in these virtual settings. And that's it. Thank you guys so much. I think we have some time for questions.
Yeah, for sure. Thank you so much, Deborah. That was really interesting, and I learned a lot from there. There was a question in the chat. It said, any templates, resources to post on our site for users to click, agree on our copyright, etc. She says, when we hire, is it Fiverr artists, webtoonist, etc., for an ebook or social media post, do they usually share in royalties? Any sample contract templates?
This is very fact specific. It depends on what the parties are willing to agree to. Royalties sometimes are paid, sometimes are not. It depends on what the payment system is. The one thing I would say is that don't feel like you can't negotiate. You can always negotiate if you're entering into these sort of agreements for any online content. They may have their standard boilerplate agreements. You can negotiate whatever suits your business. They want your business at the end of the day. And then in terms of templates, resources, I don't recommend going online and just copying someone else's, because you could be inadvertently infringing on someone's copyright, because there's copyright in the way that terms and conditions are drafted. I do have sophisticated clients who attempt to draft these things themselves. It's not a bad idea to look at what competitors are doing for inspiration or for content, not to copy and paste. I'm never going to recommend that. And there may be online resources that provide you with templates. But again, I've encountered so many issues. If you have the resources, you can throw something together. I've just done one where a client had theirs preset. They just wanted me to review it and ensure that nothing was missing. And it's usually from an intellectual property perspective, and that just doesn't take more than an hour. I would say, peace of mind. I would invest in that if you're really concerned, or look at what your competitors are doing, read the provisions to make sure, like, hey, maybe they're putting in a prohibition in there that I should be including in mine. And again, do not copy and paste whatever they're doing, just to know what they're safeguarding against, because it may be something that you're unaware of or that you haven't thought of yet. But again, I would just be wary of that, especially if you have privacy considerations. All businesses that operate in Canada are bound by PIPEDA, the privacy legislation. There's a lot of regulatory considerations as well. So if you spend some time educating yourself, look online. Otherwise, if resources permit it, hire an IP lawyer. This kind of thing is not expensive.
Okay, thank you. Does anybody else have any other questions?
Yeah, hi, it's Victory. I have a
Yeah.
question, and apologies, I'm a little sick. So I'm curious from the privacy perspective, like for instance, I use Wix and I have a store thing and people are putting in their name and information, credit card info, blah, blah, blah. So I know that's personal info, address, all that stuff. I also use Etsy, and again, the same thing on that. So I'm just curious if, if you know of like, leveraging, like, do those companies, like, I would imagine Wix also has their personal information, and so Etsy does as well. And so, like, if Etsy has a privacy policy, does that automatically extend to me? If Wix, like, I'm just curious if
It's a
how
good
that works.
question. I just dealt with this actually a couple of weeks ago, where it was sort of like you're dealing with a third party who's actually collecting the information, but you may be using the information or vice versa. So it's sort of like, I think the baseline is that every business operating in Canada, those laws apply to them. But it doesn't mean that you can wash your hands of your obligations, because, for example, there information that's considered highly sensitive is credit card information and any information that relates to health. I don't know what the terms and conditions between you and Etsy or these other platforms are, but there's, for example, obligations if there's a breach and if someone hacks into your system, if you're storing that information, or if there's a breach on their end, there are procedures that have to be, or steps that have to be taken. So if that happens on your end, just because they may have a privacy policy, it doesn't absolve you from the duties that are mandated under the legislation. So the answer is everyone is subject to it. You want to ensure that the companies that you're partnering with, that you're ensuring the safety of this information. Etsy, I wouldn't be too worried about. I'm sure they've dealt with this before, but it's worth it to have a look. And there are so many online free government resources. It's called PIPEDA. For businesses, there are brochures, and they sort of break it down in a very simple way. What you should be doing, what you can't do, what are the issues you need to consider, and educate yourself. Like I said, everything is free online, and just see it. And it provides you with a lot of insight, like, hey, I could be doing this better. I should be doing this, or why do I need to store this information anyway? How long can I keep this information? And read the terms and conditions of the companies you're partnering with. That's right, PIPEDA.
If you're creating, say, like, there's some kind of Python art where you can, use some coding to create your art, and so my son used it for his coding bootcamp business. So he uses that process and that formula, but is he like, does he own the artwork that says, learn to do this in Python or something? Like someone cannot, like, do you have to register these things? Is it given? And then I guess the question is, yeah, if you created something with a program, is that automatically yours?
It's a really good question. So the answer, as always, is it depends. There's a couple, and it's a huge area of interest now, especially in the context of works created by AI. But in a situation like that, and it's the same thing in video games, if you're let's say creating your avatars or whatever, and you're designing them using the system, it's going to come down to what the terms of use say. So built into those softwares, it will say who owns the copyright. If you're the one creating it and you're really creating something new, or you're incorporating elements, whatever, the baseline is that you own it. For copyright, you do not need to register it to have a right, to answer your question. The second you put pen to paper, the second you're creating an artistic work, and it could be literary, artistic software itself, you own that copyright automatically. You don't have to register. There are certain benefits to registering it, but you don't need to. But there are presumptions that you own it unless there's an agreement that says otherwise. So if you're engaging on, these computer programs or video games or whatever, there are terms and conditions that, let's say, your son or whoever has accepted. It may have been the first time you turned the game on or the first time you used the program, you did check a box and you accepted all these terms and conditions that none of us read. Buried in there is going to outline exactly who owns what.
So your writing and your end product artwork is automatically copyright. I can put my, at C, but the trademark you have to register. And if someone else owns it in South America, as they sell its trademark, then you cannot use that.
No, trademarks is different as well. You own rights. The second you start to use a trademark in association with goods and services, you are building what's called common law rights. It's much better to have a registered trademark, but you don't, in Canada, in the US, and the UK, any common law jurisdiction, the second you start to use a trademark, you have some sort of rights in it, but it's jurisdiction specific. Whatever you're doing in Canada, you're only building rights in Canada. And then if you're using it and you don't have a registration, you're only building rights in the geographic area in which you're using. If it helps you, I think in my first talk that I think the video is archived and saved, I go into it in a little bit more detail. So you do have rights, not as good as if you had registered rights. And if someone is using it in a different country, that's fine. They can do that. It's not going to stop your use in Canada unless they're using it in Canada.
What's the title of your past one?
I think it was, good question. Maybe Lori, you can pull that. I think it was strategic businesses.
You know what? I don't have my computer's in the shop because it's down right now. So I'm using a borrowed one. I will look it up and I could send the recording.
Yeah, IP strategies for growing businesses.
For sure. And you know what? If there's anybody here that wasn't able to attend that first one, we do have a recording. So if you want, send me an email to the makingadifference@pero.ca and just request it and I'll send you out the recording for it.
How much of copyrighted work can we quote without having to require permission? Like, can I do four lines of a poem or what?
Okay, that's also a good question. And the test is whether or not it's a substantial taking. What that means, 10 words less, is it are you stealing an entire chapter? Are you stealing a book? It depends. It really depends.
So if it's like a 10-line poem and I get 4, that's probably substantial, right? But if it's like an epic, it's probably.
It depends. I can't answer those questions in abstract, but the test is qualitative and not quantitative. So it depends. It's fact specific.
Oh, qualitative. Oh.
That's right. So if you're thinking about the Mona Lisa and you steal like a little bit of the background, whereas you steal that same little bit of her smile, there's a bigger significance in stealing the smile versus the background, is what I mean to say.
Oh, okay.
Don't steal things is the one to try.
No, I am giving credit, but I know at a certain point you actually have to ask permission, right, from the publisher or something?
The safest thing to do is always ask permission if you're going to use someone else's content.
So you write to the publisher and they take a long time, right?
Yeah, but I mean, that's what it is.
I have a question about when you talked about the web services and kind of the .com, .ca, all that kind of stuff. And like if somebody's using something I would consider fraudulently, is it just getting them to take it down, or are there also financial penalties? And I'll give you an example. I know of in my industry, there's kind of a #1 leader of what's going on, and they're in the US, they're called CADA. I'll just call it that. So they have CADA.com, they sell globally. And a Canadian competitor purchased like CADA.ca, CADA.uk, CADA. Like all of them, and just had them automatically reroute to their site. And so the way that the CADA company announced it was just on their Facebook page, said just a warning, there's copycats out there. But it sounds like they could have gone through and said, hey, they're using our name fraudulently. But I would argue they could have lost business from that. They could have had a hit to their reputation if that company is not as good. Like, does the site automatically get taken down if you win? and there's financial penalties, or it's two separate things? I'm just kind of
It
curious.
depends where you're pursuing this. If you're pursuing this through the UDRP system at WIPO, it can get taken down. You can get the domain transferred to you. There's no financial penalties. However, if you sue people in court for the similar reward with respect to the domain, you can seek costs. It's more expensive, it's a different route, and it depends where they're operating. So for example, one of the litigation matters I'm involved in, that was one of the reliefs that was requested, was that a certain domain, because they're operating in Canada, get transferred over to the plaintiff. And in the trademark, and if your action is based, let's say, on trademark infringement, which it sounds like the situation you're describing would be, you can, the federal court has jurisdiction to award any relief in the context of a trademark dispute. And in the federal court, you can request damages. So it depends. It's a more expensive process, but sort of like you said, if you have these domains popping up everywhere and you have to start suing in different jurisdictions, you rack up the bill quite quickly. So from a business perspective, yeah, are they losing a couple of clients? Okay, but you have to do a cost benefit analysis. Is it better just to notify your clients on Facebook and hope that you're negating any type of confusion? Maybe less expensive way, go through the UDRP system. You may be able to combine all the different domains. If it's a .ca, you have to go to CIRA. Other country-specific ones, it may not be the UDRP system. It sounds like it would be a lot of litigation and very expensive. So there may be a strategic reason as to why they didn't do it. But it depends. Cost-benefit analysis, I always say.
Thank you.
Okay, well, I hate to do this. We do have to wrap up because we do have that other webinar at 12:15. But I just wanted to say thank you so much, Deborah, for coming and speaking to us about all this information. It was very helpful, and we appreciate you coming back a second time, and we would love to have you back at some point in the new year. Maybe we can connect sometime if there's something else.
Absolutely.
And yeah, okay, sounds good. And I want to thank everybody for joining us today. And like I mentioned before, if you would like a recording of the first webinar, you can send me an email and I can get that out to you. So thank you so much again, and everybody have a wonderful day. Thank you.
Thank you, guys.